Ames Public Library for how Iowa's proposed constitutional amendment could impact public safety, a program brought to you through a partnership with Ames Public Library and the Ames and Story County League of Women Voters. I'm Megan Klein-Hewitt, Adult Services Manager here at Ames Public Library. The library's mission is to connect you to the world of ideas, which we do through diverse, inclusive, informational resources and programming like tonight's event. About through our current issue of Page 1 or by events email. Comments on programs, collections, and services are always welcome, so please take a moment and leave your thoughts in our comments box. And of course, consider checking out materials related to today's topic before you leave. All of those items can be found at the table by the door. Tonight's event is being recorded and will be posted to the Ames and Story County League of Women Voters Facebook page. And now join me in giving a warm welcome to John Klaus, former City of Ames attorney, and member of the Ames and Story County League of Women Voters, who will give us tonight's program.
Thank you. Can you hear me all right? Am I getting across? You can hear me fine? Okay. This is the October event for Learning with the League. As you may know, every month the League of Women Voters puts on a presentation on some issue that we feel would be helpful in enabling you to be an informed, educated, knowledgeable voter when you vote. It's always nice to know what you're doing. So tonight we're going to be talking about a proposition, public measure number 1, that will be on the ballot this fall. It has to do with guns, the regulation of guns, and we're going to compare it with the Second Amendment, which you all know about. But this is a new measure that is similar in some ways, but profoundly different in other ways from the Second Amendment. So we'll talk about that. And a wise judge once said, "A page of history is worth a volume of logic." That was Oliver Wendell Holmes in a bank practices case in 1921. And I don't know how it applied to that case, but I think a page of history is very important when we're talking about guns and gun regulation. So we're going to be spending time talking about guns in America, historic guns in America, historic gun regulation in America, and we'll be talking about the implications of those regulations, how they came to be, and what good effects and what bad effects they may have had. So with that, let's start a little history on how we came to have this proposition before us. It all began back with House Joint Resolution number 13. It was introduced by Representative Windschittle on April 3rd, 2017. And not too long after that, it was withdrawn on March 19th, 2018. Why it was withdrawn, I don't know, but the word is that there was some mistake or failure in publication by the Secretary of State, so they had to start over again, getting a proposition on guns before us to vote on. So we did Senate Joint Resolution number 7, and that was passed and sent to the Secretary of State for publication on February 8th of 2021, and it was enacted in 2019 and in 2021 Assembly. It is published and is now on the ballot. It will be on the back side of your ballot, and it will take 50 votes to pass. That's all there is to it. It's yes or no. If 50% of the voters vote yes, it's passed. If it's less than 50% of the voters, it does not pass. So let's take a look at what this proposition is. Now, I've highlighted the last sentence here because that deals with strict scrutiny, which is something that's very strongly supported by the proponents and is very definitely regretted or rued by the opponents. So we're going to talk about that, the phrase. But before we get there, there are some other words I want to draw your attention to. In the second line, you see the word sovereign? Sovereign state? Why is that in there? Well, I don't really know. but I think you should be aware that sovereignty has some jurisprudential significance. In 1993, in a case called Brady Handgun Violence Prevention Act, a state law enforcement officer was required to do background checks. Now, the sheriffs from Montana and Arizona objected to making background checks. And so they brought a lawsuit, and they argued that under the 10th Amendment, the state of Montana and the state of Arizona were sovereign, and the United States of America could not conscript or draft their officials to perform federal duties. And the court agreed with them and ruled that the federal government could not make sheriffs in Arizona or sheriffs in Montana or any other state do background checks because they were not employees of the federal government, they were employees of another state. And this concept of dual sovereignty was talked about. Interesting stuff. Not much public awareness of these concepts. But I thought perhaps that word sovereign is in that proposition because the people who are proposing it place a high value on thinking about the sovereignty of states and states' rights. And perhaps they're setting a little warning to the federal government. Be careful with the kinds of laws you pass that affect gun rights, because we may assert our rights as citizens of a sovereign state. The other words that I think deserve some special attention are any and all restrictions. The Second Amendment of the United States Constitution controls the activities of the federal government and of states and cities, other lower levels of government, with respect to the governmental actions that they take. This proposition is of a different kind. It doesn't regulate states' actions, it doesn't regulate cities and towns. It applies to people. And it is possible that any and all restrictions of this right could be creating a new cause of action, a civil cause of action, by which a citizen could bring a lawsuit against another citizen with respect to something that affects or infringes upon their rights to bear arms. A question came to me not too long ago from someone who was running a rooming house, and they wanted to know if they could, as the owner of the rooming house, say, no guns allowed here. I didn't know the answer, and I still don't know the answer, but that might be something that's pertinent to that kind of decision. If the operator of the rooming house says, no guns allowed in my rooming house, or my restaurant, or my bar, could someone else say, we'll see about that, and bring a lawsuit in the state courts of Iowa to challenge that and say, no, that is a kind of restriction of my right to bear arms, and so I'm suing for a writ of mandamus to command you to allow me to have my guns in your business place. That's a possibility. So the contested issue here of subject to strict scrutiny is strict scrutiny is a term that's been developed in the federal courts pertaining to First Amendment rights primarily, and it is the highest standard of review that the Supreme Court applies and federal courts apply when reviewing actions of the federal government or of a state government. Strict scrutiny requires that any limitation on the fundamental right be narrowly tailored. That means it can be no broader in its scope. It cannot take any more effect on anything other than what is absolutely essential to achieving a compelling objective. Now, you may be asking, what is a compelling objective? What does narrowly tailored mean? And the answer will never be precise, because adjudication is not computation, and judicial review is more rhetorical than mathematical. So there's always going to be room for argument on the question of whether or not something is narrowly tailored, sufficiently narrow, and whether or not whatever you're trying to do is a compelling objective. And we'll have arguments about that. We still do, always do. This is an NRA-backed proposition, and I'm going to read what was a press release from the NRA when it was first coming out as Joint Resolution number 13. The press release was issued on Friday, January 26, 2018. You may not have noticed it when it came out because that was the same day that front page news was that President Trump was going to fire Robert Mueller and the Justice Department threatened to resign. So this is what the NRA's press release was. The Iowa legislature is considering House Joint Resolution number 13 to add a right to keep and bear arms to the state's constitution. Should the introduced language eventually be adopted, the Hawkeye state would become the fourth, behind Louisiana, Missouri, and Alabama, to explicitly designate strict scrutiny as the required judicial standard for adjudicating restrictions on the right to keep and bear arms. This change would rocket Iowa from one of the few states without any constitutional rights to arms into an elite group that provides the strongest possible protection for the most fundamental of civil rights. And later on, that's not the whole press release, but it concludes with a statement to the effect that this proposition, if passed, would create an iron wall around our rights to keep and bear arms, or around our gun rights. Later on, after this proposition was withdrawn and we went to Senate File 7, the Des Moines Register interviewed another supporter of the new proposition. His name was Richard Rogers, and he was a board member of the Iowa Firearms Coalition, a gun rights advocacy group. His statement was, quote, "Those who oppose the free exercise of the right to keep and bear arms have been trying for over 100 years to get around, and we view it as they're trying to get around the language of the Second Amendment. And frankly, they've been very successful. We wanted to protect the right. So that's why the strict scrutiny is in there." So this is all about protecting as much as possible the right to keep and bear arms. And the proposition, if passed, would probably be very helpful in that regard, primarily because it provides an easy access to challenge state laws. Challenging a state law under the Second Amendment requires bringing a lawsuit in the federal court system. But challenging a state law in the state court system is a lot easier. You don't have to go to the federal courthouse, you don't have to go to the Federal Court of Appeals, and you don't have to be selected by the Supreme Court as one of the cases they'll choose to hear. So having a state constitutional amendment will be a great facilitator of litigation challenging state regulations. And it can and it will be used to challenge all regulations or any regulation that's currently on the books. It won't be just new legislation. It'll be the existing legislation. And Iowa has a lot of regulations that affect guns in one way or another. There's a whole chapter of the Code of Iowa, chapter 724, dealing with these restrictions and regulations. And there are also more regulations interspersed throughout various chapters of the code. They're all now would be subject to the possibility of review under the proposition. So now let's take a look at the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's a picture of the state militia of North Carolina. They look very well regulated, don't they? The Constitutional Convention met in Philadelphia from May to September of 1787, and the Constitution, including its Bill of Rights, was ratified in 1789. But the ratification of that Constitution wasn't easy, because the newly freed states were concerned about this new thing, the federal government. They had fought hard against the British and won their independence. And they were afraid that this new government, and they saw it less as a government, but more like a treaty or an organization that was bringing states together, independent countries. And they were afraid that this federal government might form an army that would then be capable of tyranny over the states, taking away states' rights. And so Hamilton, who was a proponent of the Constitution, wrote long and wordy articles to try and sell the Constitution to the states. And his basic argument was that states had nothing to fear from the federal government, because the federal government was no match for the state's militias. And that is quite possibly true at that time. Because in those days, state militias were very powerful. Every adult white man was required to belong. And every white man was required to own a gun, and he was required to bring his gun when duty called. We know these armed men, as patriots, the Minutemen, the citizen soldiers who fought the British Army, and after 10 years of fighting, won. And they were seen, and still are seen, perhaps, as emblems of a safeguard against tyranny. So that's probably what inspires many people in their support of gun rights, that tradition. Now, the Iowa Constitution is one of only 6 states' constitutions that does not have some provision on the right to bear arms. We have a Bill of Rights, but it makes no reference to a right to bear arms. By the time that the Iowa Constitutional Convention was convened in 1857, the people weren't afraid of the federal government anymore. They had other things on their mind. I've read the rather tedious 2 volumes, I haven't read every word of it, but of the Iowa Constitutional Convention of 1857. And they were more concerned with tyranny by corporations and banks than of the federal government. They spent an awful lot of time arguing about the rights of freed slaves and of indigenous people. And it's interesting, there was quite an argument about taking the word white out of the Iowa Constitution. And they argued and argued and argued over that. And every time I would kind of leap ahead saying, well, are they going to get this settled? And I would think that maybe they had decided to take white out. And this guy from Hardin County would come back and they'd, oh, well, let's put it back in. And then this guy from Henry County would come back and argue to take it out. And at the end, the result was we actually had 2 constitutions submitted to the voters. One included the word white and one did not. And which one do you think got passed? It was the one that did not have white, that did have white in it. It did. And it stayed in the Constitution until after the Civil War. So, but anyway, the point is they had more on their mind than guns because they were that far removed, over 70 years from the fear of the federal government. There was a militia provision in the Iowa Constitution, but unlike the militias of old, the militia in 1857 was recruited by the state government under the direction of the state legislature. They were funded by the state legislature, and it was no longer a reliance upon individual men having their guns and bringing them to duty. There was something I read indicating that the idea of having every man own a gun, it was a budgetary consideration. It was a way to having to avoid buying guns for your army. And these armies were very good. The citizen soldiers of the 1770s, 80s had a lot of practice. They had fought in the French and Indian wars, and they were skilled. And as Alexander Hamilton remarked in Federalist 29, he states, if circumstances should oblige the government to form an army of any magnitude, that army can never be formidable to the liberties of the people while there is a large body of citizens, little, if at all, inferior to them in discipline and the use of arms, who stand ready to defend their own rights and those of their fellow citizens. And when I read that, I thought, what is he saying? Is he talking out of both sides of his mouth? Because he's talking about a disciplined group, and then he's talking about their rights to defend their rights and those of their fellow citizens. And then I realized this is how we got the Second Amendment. This is what James Madison relied upon when he drafted the Second Amendment that says a well-ordered militia. This is the disciplined part of it. And the right of the people to bear arms. This is the individual right part of it. And the two are moored together. The two are tied together. Gun ownership is an American tradition. It's something that's been admired for the patriots. It's something that's been sort of a tradition. When we read the Second Amendment, we see that it is referring to the right to bear arms. It's not a right to bear arms. It is the right to bear arms. Because the people at that time knew that right. They understood it. It was not just, it was something that had come to them through the English common law. It was the right, and it was defined. And they had their, it was sort of like an unwritten understanding of what the limits were and what the obligations were. Gun ownership is an American tradition, but it has always been attended by moderation and restraint and regulations. As you see here, in 1686, New Jersey prohibited wearing weapons. And after 1750, Massachusetts, North Carolina, and Virginia did also. These are colonial era regulations. In the 1800s, 38 states passed such laws. 5 more did in the 1900s, so that by the time of the turn of the century, most states had laws limiting and restricting and abridging in some way the right to bear arms. And that was true even in the Wild West. This is a picture, maybe many of you have seen it before. It's a common picture. It's from Dodge City, Kansas, when it was a frontier cow town. And it says, the carrying of firearms is strictly prohibited. That was a common sense gun regulation in Dodge City, Kansas. When the cowboys would come up from Texas with their herds, get some money in their pocket, want to have a good time. It's probably a good time to put the guns away too. There's some key court cases that we should talk about. For almost all of the recorded history of the United States, the Second Amendment provision about a well-regulated militia controlled the right of the people to bear arms. But in 2008, that coupling changed. And in the case of District of Columbia versus Heller, the well-regulated militia does not control, but the of the people controls. And it creates an individual personal right to keep and bear arms. And that has changed a lot, because we are no longer required to have some type of institutional supervision over the right to bear arms. The right to restrict how arms are kept or carried is no longer tied to a constitutional provision. And the court in District of Columbia versus Heller recognizes that that's going to be a problem. But Anton Scalia, the judge who writes the opinion, over and over again stresses that, well, we just have to be mindful of the well-regulated militia language, because it will inform the individual fundamental right to bear arms. And he tries to reassure us by saying things like, there's still possible room here to regulate unusual and dangerous weapons. It's possible to make regulations that pertain to what he refers to as sensitive places. And we'll talk more about that later. The other important case was decided just this past summer, 2022, New York State Rifle and Pistol Association versus Bruen. New York had a law that said that to carry a pistol, a concealed weapon, you had to show a need. You had to show some good reason to do so. And that was challenged, and the U.S. Supreme Court, in the case of the Pistol Association versus Bruen, said that the only thing to consider is historic tradition. Historic tradition. And you know, I have some encouragement in that because we have a history. We have a history of regulating guns, and so maybe we can retie this right to bear arms to some disciplining factors that were traditional in America. But I'm not too encouraged by the cases that have come down since then. 3 of them are noteworthy. In August, a Texas federal judge ruled that the Second Amendment protects the right of 18 to 20-year-olds to carry handguns for self-defense, even though evidence was presented that nearly half the states in the 1800s had laws restricting gun ownership by young adults. In September, a Delaware federal judge stops enforcement of a law against ghost guns. One might consider ghost guns to be uncommon and dangerous, unusual and dangerous. But the court ruled saying that despite the proof of 24,000 untraceable firearms at crime scenes, there was no evidence presented to prove that such homemade guns are not typically possessed by law-abiding citizens. So the burden of proof is now shifted. So the burden is now to show that it is an unusual weapon. And what might have been an unusual weapon changes. When I was in the Army in 1967, we had, our standard issue was what is called an M14, different color. But we knew there was a new weapon coming out called the M60, which is the military version of the civilian AR-15. And it's a frightening weapon, it really is. It is very dangerous because the ballistics of the wound, it basically liquefies flesh, pulverizes bone, and the very high velocity, very small, it's only a 2.2 millimeter projectile, but it has a lot of propulsion behind it, and it tumbles through the air. If it hits a twig, it can ricochet. If it hits the body in the hand, it can come out through the back of the head. It's just, and there was real controversy in the Department of Defense as to whether or not that was an inhumane weapon. But they've adopted. But you could certainly see how you could argue that an assault weapon of that kind would be an unusual and dangerous weapon. But can we still argue that it's unusual when you can buy them at Walmart and so many people have them? They're not unusual anymore. So maybe that train has left the station. In October, a New York federal judge ruled against the New York law prohibiting guns in Times Square. The theory was that Times Square was a sensitive place. And a lot of people packed together of all kinds, no predicting for sure what's on everybody's mind, just that there's a lot of people in one place at one time. Now that decision was supported, involved an argument by the state of New York that there are laws dating back hundreds of years in New York banning guns and prohibiting guns in fairs and markets. And the judge says, well, a couple old laws do not make a tradition. So where are we going to find the answers? That's going to be litigation. There'll be more litigation. So what's the prognosis for the future? I think eventually there's probably going to be another Supreme Court case. And if the Iowa proposition passes, there will be more litigation on how that affects existing laws and people who are being prosecuted under those existing laws. If you're a lawyer and you're representing a client who's being charged with violating any law of Iowa affecting their carrying of guns, storing of guns. You'll be derelict in your duty if you did not challenge it under the proposition of strict scrutiny. And what does strict scrutiny mean? As I said, it's not precise, it's not mathematical, it's rhetorical, and it's unpredictable. So passage of a new constitutional amendment to the Iowa Constitution bring about more litigation and more uncertainty as to what the law really is. The other thing to bear in mind is strict scrutiny. Carolyn, do you have a question?
No, I was read it out.
Oh,
You wanted to do Q&A.
okay. I'm sorry. So, strict scrutiny is a concept that was developed by the U.S. Supreme Court in its cases. And it has its own rhetoric, its own arguments as to what constitutes strict scrutiny. The Iowa Supreme Court will not be bound. It will certainly maybe be influenced by, but it will still be at liberty to find its own way as to what strict scrutiny under the Iowa Constitution is as opposed to the federal Constitution. So, these kinds of concerns are laid behind the decision by the League of Women Voters when they got together in June for their annual council of league presidents and officers and anyone else who wants to come. They decided that it was contrary to the standing principles of the League in support of public health and in support of common sense gun regulations to have an active opposition to the passage of this law. So that's where we're at. We have the League passing out leaflets and conducting seminars, getting poor wretches like me to talk about it, and the gun proponents making their arguments. But it's an important question, and I think we need to be mindful of some gun death data. States with more gun control laws have lower rates of gun homicides and suicides. The states that have adopted the strict scrutiny amendment are currently ranked 3rd, 4th, and 5th for gun deaths. And there are 3 states that have adopted the strict scrutiny concept in their state constitution. They are Louisiana, Missouri, and Alabama. And there actually has been litigation in Missouri and Alabama because, as I mentioned, lawyers will use this proposition and their clients under existing laws. There was a law in Louisiana that made the penalty greater for selling drugs. And so the first case under the strict scrutiny law or constitutional provision in Louisiana was, did that law a more severe penalty if you carried a gun while you're selling drugs, a violation of the right to not have their right to carry guns infringed. And the court got through that all right. Basically they said, this has already been adjudicated in this state, and we've looked at the record of that case, and we've decided that we did use strict scrutiny in making that decision. So it's been adjudicated. But it's predictable that there will be litigation testing existing laws under the new propositions language. So now we can do questions and answers or make any comments or suggestions that you might want to do. We have a microphone that we can pass around if you have a question or comment you want to make.
I have a microphone back here in case anybody
Any questions or
wants to
comments?
raise their hand if they have a question.
You have one right here.
Thank you.
Doesn't the Constitution say anywhere that the government has a responsibility to protect me?
Not that I know of. They have, obviously, one of the functions of government is to provide for the general welfare. But, a specific requirement that to protect you is, I don't know where you would find it. I've often thought, there should be something like a freedom from fear, something like that, And maybe someday somebody can develop an argument like that. Under the 14th Amendment, we all are guaranteed liberty, And maybe liberty does entail being free from fear. So maybe somebody will make that argument and win. But we're in a kind of a different place right now. We got a lot of work to do in developing what the reasonable regulations that will alleviate the fear can be. Historic tradition. What are the historic traditions of regulations? There's always been regulation, but when we went away from the decision, and one didn't go away from the decision in Heller, but when Bruin took it one step further and say, it's all going to be determined by historic tradition, and we're not going to go to any process of evaluating relative burdens and that sort of thing. There was a proposition that when you argue gun laws, you could say that the burden under the new laws pertaining to new weapons need to be comparable to the burdens on gun ownership under the old regulations on old guns. And that was a headbuster for the court, and they just said, no, we're not doing that anymore. It's strictly on historic tradition. And what is that going to be? Who can say what that will be? It will just have to be litigated. And perhaps the city of New York, in their efforts to regulate guns in Times Square, are working on a historic document, or document on history that will be persuasive to the court and restore some degree of regulation in that sensitive place. And it'll just be a process of trying to work through this, trial and error. Yes, sir.
Wasn't the argument made in the Wild West for restricting all guns in the city limits based on exactly that premise, freedom from fear, that the citizens were tired of having their cities, their towns shot up by cowboys and other people who just got drunk and fired off their guns, had gunfights in the streets, and innocent people died.
I think you're probably right. Not the, innocent people were probably dying too, but it was bad for business.
I got it.
It was definitely bad for business. And that 1689 ordinance that I showed you earlier from the colony of New Jersey, some of the language around that I read says that it was alarming the citizens to see people walking with a brace of pistols and a sword. It was unnerving. It was scaring them. And so that was one of the motivations behind passing that law. But right now, we don't seem to be very of the reality that this room could have several guns in it. The library does not have magnetometers. You don't know who's carrying a gun. And we're not too worried because mostly nothing bad happens until it does. So, any more? Yes.
Let me come at you with the microphone so
Yeah.
the folks online can.
I just don't understand why they are ignoring the words well regulated. How can you just blow that off. And I looked it up, and well-regulated or regulated means limited, governed, and restricted.
We had that prevailing, didn't we, as part of the right to bear arms? It was for most, like I said, for most of our recorded history until 2008. Why did the court step away from it? Well, I don't know. Maybe just because they could. Sometimes you don't know. I don't know what kind of argument, but they made that decision.
Just a bit of historical footnote. When I was in Concord, Massachusetts, where the battle took place, there's a plaque there. And the local militia, it wasn't just a bunch of local farmers who got together and said, we're going to stop these redcoats. They held off engaging until they got permission from the town council under well-regulated.
That's the case. That was a shot heard around the world. When the British troops got to Lexington, they found the Massachusetts militia formed up in the field, rank and order, and they stood their ground. And it was a standoff. The British or actually, if you call them the English or the King's Army, because the people of Massachusetts at that time thought of themselves as being British. But anyway, the King's Army and the colonial army were staring each other down until a shot rang out. Nobody knows what that shot was, where it came from. But of course, everybody started shooting then. Six colonials were killed. And the Brits went on to Concord, picked up the gunpowder, which is what they were after. Concord had a stash of gunpowder, flour, and I think some lead for bullets. Anyway, they picked up the gunpowder and started walking back to Boston, at which time the colonials took their revenge. They were really angry, and they kept snapping at the British all the way back. The British lost 71 on the way back, 71 dead going back to Boston. So it was considered a great victory, but really quite a tragedy too, wasn't it? So that's the way, that's the way we have the founding story of the Minutemen, the citizen soldiers. Yes, here, right here.
I'm confused. I'm confused on this, the fact that we have to vote on this, which you keep saying, well, we got to have all these court things will come out of it. Well, why are we voting until the courts decide what to do?
Well, that's a good question. And maybe you should vote no till the courts decide what they're going to do. But you've heard the arguments made by the proponents. They are very concerned about protecting their right to bear arms, and this is very important to them. And I don't fully understand why, but it is. And so that we're not, that's how it works. The legislation is passed, or a proposition to amend the Constitution. The people approve it, and then for the next 100 years, we argue about what it means. That's the way it works.
That doesn't make sense to me.
Hi,
We'll get to you.
if you don't have that right to bear arms, then you might as well end up, being a puppet someplace. Because I had family, most of my family got out of Germany before World War I, but I still had some in there when Hitler took over. And he started with certain weapons that were automatic weapons. And then he ended up taking every weapon from everybody. Just like Mr. Biden is trying to do right now.
Nobody's taking.
In World War II, killing millions and millions of people. Not only concentration camp, but soldiers that had to fight.
I understand your point of view.
And
So you've made your point, sir, and I understand it. It was, that was the reality. That's how the preserved their liberties countries that they thought the British were infringing on. But it took 10 years of warfare and the help of the French Navy and a lot of French Marines to finally defeat Cornwallis at Yorktown. And Cornwallis had already been beaten because 2/3 of his men were dying from malaria. So it's complicated, but I understand your point. I know what you're saying. Yes, sir.
Hi, I was wondering about the fourth bullet point. When did that replace whatever it was, and what was that?
Gun shootings are now the leading cause of death for children and adolescents in the United States. And you're
Yes.
asking what was it before?
Yes, and what year did that change?
Oh, I don't know that. I knew it when I wrote that bullet point, but I don't have it. I don't have the date. It was sometime in this, probably not too long ago. I don't think it was very long ago at all. But I think, as I recall, the leading cause of death used to be car accidents. But now we have much safer cars. The guns are probably still dangerous. Yes, son. Take the lady back there.
I'm interested in the phrase strict scrutiny. Is this the flavor of the day? Are we going to see strict scrutiny in other kinds of laws? It seems like a backdoor way to kind of get at things you don't like.
Well, strict scrutiny is developed in defending First Amendment freedoms. And that's how, and the court wanted to make sure it was very difficult to infringe or diminish your freedom of speech, freedom of religion, and possibly, I think it may have extended to voting rights. I'm not sure about that. So strict scrutiny was, the way you protect fundamental freedoms. You really make it hard for the federal government, for the state government, for the city council to have a law that puts any type of restraint on your right to speak. And the argument is that right to bear an arm, to carry a gun, is just as fundamental, sacred, just as important as your freedom of religion or your freedom of speech. And that's what the court has ruled.
I am reliably informed, I think, by a constitutional scholar that every single constitutional right comes with restrictions, and I don't see how gun rights are any different. Nobody's trying to take every single gun away. We just need control, because we are just going to see worse and worse guns. Right now, they're manufacturing the MCX Spear, which can cut through Kevlar and anything else. It is a higher range sniper.
I've read about that. I understand that product.
So
Yeah.
where do we draw the line?
Well, I don't know. But the man who, a Vietnam veteran as myself, has a legitimate concern about protecting our freedom. I don't think it's realistic to think that we will be able to fight a standing army with the same effectiveness as the colonialists did in the 18th century. But the principle's the same. And I think it's a romantic notion that probably maintains the spirits of a lot of people, but it's very dangerous and very reckless. And I think that the courts have given us a path that we can produce a new jurisprudence that, based upon historic demonstration of regulatory policies, maybe we can carry the day. But voting counts, the voting counts. And there's a chain between who gets elected governor, who gets elected president, and what kinds of attitudes are carried by appointees to the courts. That's the way it goes. But we can also affect things, not just through voting, but through our expressions and our attitudes. I heard when I was in law school a statement to the effect, well, judges read the papers too. And so they can be affected, and they are affected by what people see as important. Yes.
If this amendment passes, are the laws that are on the books going to all be up for grabs?
Well, grabs may be a little bit, but they're all going to be potentially litigated. It can be, yes. All existing laws will be subject to the new Iowa gun jurisprudence, which we don't know anything about yet because it does not exist. This will be a new kind of constitutional law, Iowa constitutional law. And you didn't hear much about that, but the late Justice Mark Cady, who died just a couple of years ago, was a great proponent of using the Iowa Constitution to articulate important principles. It was the Iowa Constitution that he used to uphold same-sex marriage, and it was the Iowa Constitution he used to uphold a woman's right to choose. And there were judges who were appointed to Mark's position after he died who rather quickly decided that, no, he was wrong. So, that's the way it works. Well, thank you for listening so patiently.
So this brings us to the election on November 8th. Back at our table, you can still register, and if you aren't registered, I can't believe anybody in this room wouldn't be registered, but I would take it to the auditor's office tomorrow because Monday's the last day you can register without having to show all kinds of IDs and proof of residency. So we could do that here. And Monday's also the last day you can request an absentee ballot request form. If you fill it out here tonight, it'll be at the auditor's office tomorrow in time. So, and if you want to know more information about the candidates that are in Story County on the ballot, we have little Vote 411 cards, and you can QR scan it. You could read about their bio. You can read about the many questions. We ask each candidate in Story County, our senators and our legislators, 4 questions, and most of them responded with answers to those. So if there's an issue there that you wanted to hear how they stand on, look it up, Vote 411. And next month, November 17th, Learn with the League will be on economics. And Peter Orazan will be our guest speaker for that one in November. And then in December, we're going to be talking about immigration. And we have a local person here talking about the difference between an Afghan immigrant, a Ukrainian immigrant, the DACA, and all these different immigrants and their statuses and where they stand and where they go, how long they can be here, and that. So that'll be on December 15th. So Learn with the League.
And what was the November date?
November date is November 17th. So thank you for coming.
Thank you, folks.
And you can always join the league.
Great questions.